Good morning and welcome to the meeting of the Maryland Public Service Commission. I'm going to try to conduct this commission meeting today with a cough drop in my mouth. We have a relatively short agenda this morning, but I'd like to make a few announcements before we address the consent and administrative items. I'd like to introduce a new employee, Sierra Wright. Is Sierra here with us today? There you go. Sierra just joined us last week in our Consumer Affairs Division. She will be the new office secretary. She brings a wealth of experience coming from the University of Maryland Medical Center, where she worked for a number of physicians and assisted them in their daily day-to-day activities. So the consumers and public in Maryland are in good hands with Sierra now on the job. Welcome. And it is, I'm not sure if it's actually officially summer yet. I don't think so. But with summer comes new interns, and we have a new OGC intern with us, Travis Jones. Is Travis here? Travis, welcome. He'll be interning with the Office of the General Counsel in Bob Irwin's office through August. He's currently a master's student at the Vermont Law School, where he's pursuing a master's of environmental law and policy. And he's currently a law student at the University of Baltimore, where he serves on the executive board of the university's law review. He has extensive experience for an intern. He's worked for the Maryland Attorney General's office in the Environmental Crimes Unit, and he's also served our country with 4 years in the U.S. Air Force. Travis, welcome. And I'd also like to announce some exciting news that we just learned of yesterday. Commissioner Anthony O'Donnell, to my right, was elected as the second vice president for the Mid-Atlantic Conference of Regulatory Utility Commissioners. For those of you who are not familiar with MACRUC, it's a 9-state organization with I shouldn't forget the Virgin Islands or the District of Columbia. So it's a regional organization within MACRUC. Commissioner O'Donnell will be the second vice president, ultimately culminating in a presidency 2 years from now. So having Maryland represented in this body is important for the state and for the work that we do. So congratulations, Commissioner O'Donnell. Commissioner Herman, I thought you'd be banging that cast on the bench. We'd hear a lot more. I'm
going to measure my words more carefully.
Just be lucky it's on the right, not the left. We do have some meeting minutes from the meeting on May 29th to approve. Is there a motion?
Yes, Mr. Chairman. I move we adopt the minutes from May 29th administrative meeting.
All in favor?
Aye.
The minutes are approved. Madam Secretary, the consent agenda?
Yes, Mr. Chairman. On the consent agenda are 2 items. They are both been filings by Alberio Energy, LLC. The first item was filed on April 17, 2019. It's an application for a license to supply electricity or electric generation services in Maryland. And the second item is also filed on April 17, 2019, an application for a license to supply natural gas or natural gas supply services in Maryland.
Thank you. Do commissioners have questions on these 2 license applications? Seeing none, are there motions?
Yes, Mr. Chairman. For items number 1 and 2, I move that we grant the company a license to operate as an electricity supplier and as a natural gas supplier in Maryland, limited to broker and aggregator services, for the customer classes and service territories applied for and recommended by staff, and that we direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Thank you. All in favor?
Aye.
Any opposed? The motions are approved. Madam Secretary, the administrative agenda.
Yes, Mr. Chairman. Item 3 on the administrative agenda is Verizon Maryland, LLC, filed on May 7, 2019, revised tariff pages. The company proposes rate changes for month-to-month and 2-year term business dial tone lines and rate group B exchanges with up to 650,000 weighted main stations effective June 7, 2019.
Good morning, Mr. Chairman, Commissioners. James Greger on behalf of staff. This agenda item concerns a request by Verizon Maryland, LLC to increase its monthly recurring charge for business dial tone lines. Public Utilities Article, Section 4-301, allows the Commission to regulate a telephone company through alternative forms of regulation. As authorized pursuant to PUA Section 4-301, the Commission in Order Number 83137 established an A4 and price cap plan for Verizon's regulated services in Maryland. Under paragraph 15 of the A4, the cap on the monthly recurring rate for a standalone business dial tone line shall increase $2 per year, and the cap on all other business basic rates shall increase by 10% per calendar year, regardless of whether Verizon actually increases the rate. Verizon may change its business basic rates at any time, except that no single rate increase may exceed $4 for standalone dial tone line and standalone business local usage, or 20% for any single increase to any other service in the business basic basket. On January 1st, 2019, the rate caps for business tone lines increased by $2. The proposed increases of $1.75 for the monthly recurring charge for a 24-month term and $2 for customers not on a term contract do not exceed the rate cap increase. The proposed rate increases are permitted under the A4. The company has notified customers of the rate increases through bill messages contained in the December 2018 billings. Therefore, staff recommends the acceptance of Verizon's tariff revisions for filing with an effective date of June 7th, 2019. Thank you.
Thank you, Mr. Greger. Counsel for Verizon Maryland LLC, good morning.
Good morning. My name is Doug Smith, State Government Affairs for Verizon Maryland. I'm here to answer any questions of the Commission. Appreciate the opportunity.
Thank you, Mr. Smith. Do you have any concerns or contentions with the statements made by staff counsel?
No, it was an excellent representation, and we support the staff recommendation.
Thank you, sir. Do the commissioners have any questions? Seeing none, is there a motion?
Mr. Chairman, I move that we accept the tariff revisions for filing with an effective date of June 7th, 2019.
All in favor? The motion is approved. Thank you.
Item number 4 is Sandpiper Energy, filed on May 2nd, 2019, joint motion to amend settlement agreement, case number 9350.
Good morning, Chairman, Commissioners. Michael Dean on behalf of staff. Item 4 is a joint motion filed by Sandpiper Energy Incorporated, which would modify the settlement agreement in case number 9350 that was approved by order number 86690 in 2014, and essentially change when a new depreciation study of Sandpiper plant would need to be filed. Under Public Utilities Section 4-102, the Commission has the power to set a just and reasonable rate of a gas company, and just and reasonable rate is defined by Section 4-101 to include a reasonable deduction for depreciation. In the last depreciation case of Sandpiper, a settlement agreement required the next depreciation study to be filed within 5 years, whereas part of the next rate case, meaning after the rate case required by a prior order, whichever was sooner. The Commission approved this settlement agreement in 2014. However, the next rate case, which was resolved in 2016 with a stay-out provision which precludes Sandpiper from filing its next rate case for 6 years or within 6 months after the company has converted at least 80% of its customer base from propane to natural gas, whichever is later. As such, as noted in the joint motion, the next rate case should not be filed until October 29, 2022. The settlement agreement from the prior depreciation case did not contemplate that there would be a 6-year stay-out provision approved in the next rate case. Since it is desirable for the depreciation rates implemented in a rate case to be as current as possible, the motion seeks to change the date when the next depreciation study is filed to be consistent with the filing of the next rate case. For this reason, staff recommends approval of the joint motion to amend the settlement agreement.
Thank you. Counsel for Sandpiper Energy.
Yes, Matt Everingham, Manager for Regulatory Affairs for Sandpiper Energy. The company agrees with staff's recommendations and is just here to take any questions the commissioners may have.
Thank you. I also agree with the recommendation. I was just curious, what percentage of your system has since been transitioned from propane to natural gas?
Currently, we're in the upper 70s. I believe it's right around 78% at this moment. I'd have to double check for verification, but upper 70s.
78%?
in that
Approximately, okay, all right. So you're almost to that 80% threshold. Thank you. Do the commissioners have questions? Seeing none, is there a motion?
Mr. Chairman, I move we approve the joint motion to amend the settlement agreement.
All in favor?
Aye.
The motion is approved. Thank you.
The last item on the administrative agenda is item 5, Baltimore Gas and Electric Company filed on January 11th, 2019, request for a waiver of CPCN requirement for a project to modify an existing overhead transmission line to improve reliability performance.
Thank you. When we last met on April 3rd, so it's now been more than 2 months, and there was an unexpected extension of our original date to reconvene. At the suggestion of Commissioner Richard, we were allowing the parties additional time in which to conduct additional discussions and negotiations. And Mr. Wilson, why don't we sit at the table like we did last time? I should have said that at the outset. If I recall, last time we were in session on this item for 2.5 hours, so I want everybody to get comfortable. Yes, and if you recall at the last meeting on April 3rd, Commissioner O'Donnell was not present, but he would like to make a statement today.
Just to make sure the parties understand, I was in Denver at a NASIO NARUC task force meeting during the last meeting, but I did have an interest in this item, and I did review the record and the video of the entire meeting, so I'm up to speed. I just wanted to say that for full disclosure, so no one has a concern. Or if you have a concern, raise it.
Okay, does not appear that any parties have an objection to your participation in this matter. Now that more than 2 months has passed, perhaps, Mr. Herson, you could bring us up to speed. I recognize that the other parties at the table recently filed some comments.
Yes, thank you, Mr. Chairman. Good morning. Good morning, Commissioners. Daniel Herson for Baltimore Gas and Electric. I'm joined today by several of my colleagues. To my immediate left is Todd Chambers, who's the project manager on this particular project. We also have in the audience here Faith Olawode and Bob May, who are engineers in our transmission planning unit. Greg Kapler, who's our environmental expert. Chanel Rhodes-Reed, who's the outreach coordinator on this project. And David Ralph, who's BGE's associate general counsel. Mr. Chairman, as you mentioned, we were last here about 2 months ago on April 3rd. At the close of that hearing, Your Honor asked the parties to meet and confer to see if we could arrive at either a full or partial settlement or a set of conditions that the parties could agree to put on this particular project, and the idea that perhaps with that the waiver could get granted. We did host a project site visit on April 15th after that hearing, so all the parties were invited to walk the line, and we did, in fact, do that. A meeting was convened at PPRP headquarters in Annapolis on May 20th. Representatives of BGE, PPRP, staff, as well as OPC attended that meeting. It was a good meeting, a productive meeting. At that meeting, PPRP presented BGE with 7 pages of conditions. There was some back and forth between BGE and PPRP, but I'm pleased to report that we agreed to a set of conditions that BGE can fully adhere to. And those conditions were attached to PPRP's comments that they filed with the Commission. Staff reviewed those comments and filed a 1-pager stating that they had no additional comments to add or conditions to add. OPC filed comments. They're still objecting to the granting of a waiver. However, I believe they stated at the end of their comments that if the Commission does grant the waiver, they would like to see those conditions imposed as well. Those conditions are pretty wide-ranging. They cover a number of topics: rare, threatened, and endangered species, vegetation management, environmental issues, EMF, site access, obligations to update PPRP and staff at all steps of the process, adhering to multiple regulatory requirements, having an environmental monitor on site at all times to manage the project and make sure that we're adhering to those conditions. We're going to have somebody, I believe, scanning the fence around the project site to make sure there are no bog turtles. present, that sort of thing. If you have specific questions about environmental issues, we have the folks here who can answer those. A couple other updates. The Pennsylvania Public Utility Commission, we learned yesterday, just approved the PPL side of the project. I brought copies of that order. If the commissioners would like to see that, I can pass those out. I just learned about that yesterday. I think they actually approved it on May 23rd at their public meeting.
And Mr. Herson, this is an order granting CPCN for PPL to construct the project to the Maryland line?
Yeah, I don't believe they call it a CPCN. This is their equivalent of the shortened waiver. Their equivalent of a waiver process, basically. And in the order, they set forth the requirements that they have to find in order to grant the expedited approval.
Do you have copies for
I
us?
do have copies.
Okay, if you could approach the secretary.
I believe the standard that they have to follow is on page 5, section 57.72.
Let's just have 1 minute for the
Sure.
commissioners to read that section. Okay, thank you, Mr. Herson. You may continue.
The other update I wanted to provide, it's not really an update, but there continues to be no objection to this project by any elected officials or any of the landowners or residents of the area adjacent to the project site. So we continue at BGE to think that this is a good candidate for a good cause waiver. And, let me start by saying it's not because the work needs to get done. I sat here about a year ago and I heard Commissioner O'Donnell and other members of the commission state that just because a project needs to get done is not a reason to grant a waiver, good cause or otherwise. I don't dispute that. We agree with that. But there are other reasons why we think this project is a good candidate. I mentioned them at the April 3rd hearing. I'll just run through them real quick again. The system and customers will benefit from the work being completed much sooner if a waiver is granted as opposed to the full CPCN process. There will be reduced costs, and it will free up scarce agency resources. We'll be able to keep pace with PPL, since they'll be doing the work on the Pennsylvania portion of the line. And to do both sections at the same time will enhance the reliability benefits, as opposed to either of us doing it separately. There are no additional real property rights required by BGE here. All of the work is being done on property either owned by us or to which we have existing access rights. We're reducing the environmental footprint significantly. We're going from 40 towers down to 12 monopoles. These will have smaller foundations. The operating voltages will remain the same at 115 kV. We have extensive oversight of this project from state and local officials and agencies, including MDE, Federal Aviation Administration, Maryland Aviation Administration, Department of Natural Resources, Wildlife and Heritage Services, Maryland Historical Trust, Maryland State Highway Administration, and the Harford County Department of Public Works. As I mentioned on the April 3rd hearing, we've done extensive outreach on this project. We've had community meetings. We've sent 3 sets of letters. We've actually had individual meetings with certain homeowners and landowners, and we have no objection from anybody in that vicinity or elected officials regarding this project. And in fact, the Community Association Board and Council Member Schroeds filed letters with the Commission in support of granting the waiver. We have an extensive set of conditions now that BGE has agreed and will follow, including the environmental monitor that I mentioned earlier. And finally, I want to say that the Commission, if they grant this waiver, is not setting a precedent for future waivers. Our position is that each waiver request that we bring before this Commission has a unique set of circumstances. It either stands or falls on its own. PSC will have the chance to analyze any future filing. Parties will have the chance to analyze it and provide comments. So I want to stress that approving this waiver here for this particular project does not, in our mind, equate to an automatic approval of a waiver request for future projects. So for all those reasons, we respectfully request that the Commission grant BGE the waiver for this project for good cause.
Thank you for the summary, Mr. Herson. I'm glad to hear that the parties accepted Mr. Chambers' offer to actually walk the line on April 15th, and that all 3 agencies participated in that. And it sounded like that there were productive and good faith meetings since then. Counsel for PPRP.
Good morning, Commissioners. My name is Sandra McLemore on behalf of Power Plant Research Program. Today I also have with me David Tansabell, the Director of the Power Plant Research Program, as well as Bob Sadinsky, who is a project manager for this project. Mr. Tansabell can answer any questions you may have on the letter that we submitted on May 23rd, as well as our position in our April letter. And Mr. Sadinsky can answer any questions concerning the conditions that you may have.
Thank you. And if either Director Tansabell or Mr. Sadinsky wish to speak at any time, please approach one of the podiums. Sorry that we don't have enough capacity at the table.
First, I would like to thank BG&E. We have worked with them pursuant to the request by the Commission. I would like to point out, however, for the reasons set forth in our initial response, we continue to recommend that the Commission deny BG&E's waiver request. However, having said that, we're going to just stand on our letters that we have submitted to you, unless you have questions, which we'll be happy to answer.
Thank you. I believe we will have some questions for you. Counsel for the Office of People's Counsel. Good morning.
Good morning, Gary L. Alexander for the Maryland Office of People's Counsel. I don't plan on going over every comment in the letter. I know you've all read it. But I would like to highlight 3 things, or I don't want to limit a number.
I'm
few
counting.
Things.
I'll count.
I know, I've learned. So let's just say a few things. And let me address the last point that Mr. Herson made about precedent. The Commission, formally by law, has no precedent. It's it's directed by law to weigh each case on its facts, and it's not a court. So other than the Court of Appeals or Court of Special Appeals, which we all have to follow, including the Commission can change its decisions. But the Commission tends, for a number of reasons, including a possible reversal, to not act in an arbitrary and capricious reason, which is in the statute too. So while I agree with Mr. Herson that this would not create a formal precedent, because technically there is no formal precedent with the Commission, the Commission doesn't change quickly its decisions without a very detailed decision to explain why it is changing something. And the reason is because even though I agree with Mr. Herson that every case is decided on its facts, the fact is that every company, I'll just say electric company, but it could be gas, that comes in for a waiver request will be using this as an example of why they should grant it, because you have granted it before. And that sets something both for PPRP and for staff and for OPC and also for the commission, because it, as a general practice, when it has veered from the statute, well, not from the statute, when it has veered from past practice, it generally tends to explain itself well, both because the commission cares and in having looked up to see about potential appeals. So we would say that it does cause a concern, not about formal precedent, but about practice and procedure in the commission. As we have noted twice in our letters, we believe that the good cause should have a time component. And the time component meanings is that if you're going to really want a waiver, you should have a good reason for it, that it needs to be done now and not have to go through the process. BGE was very cooperative in discovery. We thank them for that. We got straight answers to our questions as detailed in the letter. There were a lot of facts that we uncovered, but the main one is that nothing's happened in this line for 5 years for Maryland. Now, there's been numerous problems with the PPL line, but there's been nothing. In contrast, 5 to 10 years ago, there were a number of problems with this line, including some safety violations. All of those are gone. For the last 5 years, nothing has happened on the Maryland side of this line. And thus, BGE has had 5 years to come in for a CPCN, and from what I can tell, apparently they were just waiting for PPL to decide to do its part of the line. Maryland gained nothing from that. BGE is going to the work it has to do, and PPL is going to do the work it has to do. There's no connection between the two, and so we think it does set a precedent, actually, and again, an informal one, a practice and procedure, not a formal precedent, legal precedent, of the third way that a number of the commissioners and Mr. Chairman were very concerned about at the first meeting, that you were leery of creating a third way, and thus, given the facts of this case, that nothing has happened in the last 5 years, that no Maryland residential customer ever experienced an outage in this case, that this is not a case that would be easy to distinguish between for a waiver request from other waiver requests that come in, because BGE could have done this during the last 5 years. And finally, we do reiterate, and we specified this in the first letter, that we support BGE's outreach to the various agencies, to the people that it said, and we think it's something that all utilities should do. But it doesn't satisfy the statute. It doesn't satisfy mentioning the notice to all people in the region rather than the affected people. It doesn't take into account the community, the notice to the county councils and things. There are a number of requirements under the CPCN statute that, notwithstanding we think that the outreach was good, does not satisfy most of these requirements. So that that's our position. We do say that if the commission grants it, they should accept all of, only with PPRP's conditions. But as PPRP noted in its letter, they couldn't do a full review, and these conditions would be likely amended, added to, changed if they did have the time to do the review under the CPCN statute. So they've expressly noted a caution. And that's my presentation, Your Honors. Thank you.
Thank you, Mr. Alexander, for explaining the position of your office. Counsel for the PSC's Staff Counsel.
Thank you, Your Honor. Peter Wilson on behalf of staff. Staff's position remains unchanged. Engineering Department reviewed the project from an engineering standpoint and approved it. But we do rely on PPRP for formulating environmental and other conditions, and that is where we remain. So we would join with PPRP in offering their conditions and supporting their position on this.
Thank you, Mr. Wilson.
Chairman, I have one thing I forgot to note. On page 5 of 9 of the conditions, there's a very important typo that I wanted to address. It says any bog turf ties. It should be any bog turtles. So I just wanted to make sure.
This is Roman 5.
It's on page 5, and it's 6 on the bottom, if you look at that one.
Bog turf ties, yes. Okay.
Thank you.
Very good. Thank you. Again, I'm glad to see that the parties used the 2-month period constructively. I note that we now have 16 conditions from PPRP, which have been agreed to by Staff Counsel. As we discussed last time, I mean, some of these do appear to be generic conditions, but as Director Tansable noted, with some hesitancy, that these are case-by-case situations. And then it appears that some of these conditions were crafted specifically for this 1.8-mile project. With respect to the second tranche of recommendations, that PPRP stated that they are unable to provide a recommendation because they either didn't have time or resources or lack of information. How does this factor into the Commission's weighing of BG&E's request here, whether it be vegetation management or the fact that PPRP hasn't had time to consult with county representatives, although at least one county representative filed documents in support? How would you ask that the Commission approach these bulleted items if the Commission were to grant the utility a waiver?
I'm going to let Mr. Tansable take this because he's been thinking about this with...
Chairman, Commissioners, David Tansable, Director of the Power Plant Research Program. Yes, so a lot of these conditions, and again, we didn't want, we weren't placing blame on BGE as OPC was stating. They've been responsive to everything we've asked for, but we just have not had time to get to all of these items, such as a vegetation management plan. And again, a lot of these items are included in an ERD that is provided during the filing of a CPCN, and so just things that were not included in there. Again, we wanted to just alert the Commission that these were areas that we would normally get into, but just didn't have the time, and it was stressed that there would be no extensions to our filings. We were very cognizant of having this ready and having this ready in time to meet with BGE to discuss to change. So that even pushes the window up further when we had to get everything ready to be able to meet with them. As far as how to remedy that, I'm not sure. I don't know if a waiver could be granted with continuing discussion with BGE in some areas, but
obviously communications and discussions can continue, but if and when the commission grants the waiver, it would be hard for the parties to continue to negotiate the waiver with the utility at that point. Just taking a look at some of the bulleted items, such as traffic management, I recognize that, at least for the state road, SHA has already provided their permit. Is that correct, Mr. Herson?
I'm sorry, I didn't hear the question. Mr.
With regard to the bullet regarding traffic management, and that PPRP hasn't reviewed traffic patterns, perhaps, I know Mr. Tansabel stated concerns with one-way traffic on the roadway. Has SHA reviewed your traffic patterns and roadway points of entry and blessed that yet?
I believe they have. We did go to them, and we needed to get a permit for them because we will be interrupting traffic on several of the access points, and I believe at this point we do have that permit.
Yeah, as well as the county.
The county has reviewed your traffic management plan?
Yes.
And approved it?
Yes.
Okay. So I don't want to hit these on sort of a haphazard, scattershot approach, but looking at others, the official docket, I recognize that is a concern. That's one that if the commissioners agree, and again, if the waiver is granted, I don't want to prejudge anything at this point, we could actually docket this as a case number and therefore provide a public repository for those documents. If the commissioners would indulge me, I'd prefer that we just stay on the topic of conditions before we move to other questions that the commissioners have. So let me just open it up at this point with respect to conditions. Commissioner Richard.
I think the chairman's question actually covered most of my issues, but I did want to go back to really the conditions, and in the very top line, the number 1, it does say, shall comply with all applicable local, state, and federal laws and regulations, including but not limited to. That's a pretty broad catch-all. Is that right? I mean, does that ensure also with your traffic issues that local requirements, state requirements, every existing requirement permit will still need to be adhered to?
Yes, sir. Yes, sir. That's correct. I will say that I mentioned traffic because there are in some instances when, due to concerns from locals or that we have in CPCNs, put in restrictions on what road direct traffic patterns during certain times and during certain access points. And we just haven't had time to look at that. Whether or not that's needed, we're not saying it is needed. We're just saying that it's something we didn't look at yet, but it is something we but yes, that is pretty standard language to ensure that they comply as a backstop with all local, which is, which they have to do if they would have to do anyway, but the CPCN process usually encompasses everything and can sometimes go a step beyond that backstop.
And Commissioner Richard, it's also the devils are in the details on the shall comply with. What exactly you have to do to comply with those laws is sometimes something that we have to discuss during the CPCN process. So we have that as the first condition, but then the details of how that is actually implemented is something that we talk about during the CPCN process.
Okay, but as a construction project, this is still going to be, applicable. All the local, state, and federal laws will be applicable. Is that correct?
Of course.
So the company will, have to comply, or otherwise any of these entities could step in and enforce these requirements. So nothing really changes.
So that's correct.
And that is stipulated very clearly in your conditions now.
Sir.
And that would also, with some of the wildlife issues, again, not to take a scattershot approach, but all those requirements that exist on all levels of government, it will exist, based on these conditions.
Sir, an example, like a time of year restriction, they are not planning to do in-stream work. It is possible that they may end up needing to. So if it is even possible, we usually consult and put that in the condition so that everything they need is in there. But we haven't, although they don't plan to do it, it's a possibility that there is wetlands there that we haven't had a time. So that's an example.
And since this is an existing line, I'm guessing that there is a vegetation management requirement now. Is that correct?
We haven't reviewed their vegetation management plan. So you're not aware of what the plan is for this section.
For transmission lines, isn't there a federal also vegetation
Well,
management?
there
requirement?
are federal requirements
Right.
that must be met, but as far as, there are, for safety and electrical requirements, but then there's a management plan on how they man to maintain that right of way. That is beyond the federal and
Okay.
requirement.
But whatever is existing now, if we take an action in favor of the waiver, those won't disappear. They will still be in place.
So, yeah, they must,
Okay.
still comply with the federal requirements on right of way.
But one of our concerns with this is there's no current CPC in too, so that was one of the other matters.
Okay. All right, thank you. Oh, sorry.
Just following that, the comment I believe Ms. McLemore take is that I don't know who said it, but the devil is in the details. It does create a question about enforcement. In other words, if the conditions are not specifically detailed, and if PPRP, usually we don't get involved, but if PPRP differs with, say, the vegetation management plan that BGE is put forth, then the question comes in, it's then ambiguous, and then the commission has to decide it because it wasn't agreed, it's not thorough enough. So, depending on how this plays out, this could come before you as a dispute, basically an analogous or identical to a contract dispute with ambiguous language, or compliance with, you were asking about the federal and the state laws, but particularly the state laws, not the federal ones, the state laws that we have. There's more ambiguity than PPRP believes is comfortable. And frankly, I would say this, that even though we generally don't get involved in some of these details, we might as well want compliance, and we may be involved in that dispute too, have to weigh in on how to interpret this document rather than the conditions of PPRP.
Okay. Yeah, not to monopolize the time, but how would we enforce it now? I mean, the fact is there are state, federal, and local laws that apply, and so therefore if someone brings a complaint, wouldn't it first go to the authority whose law is being broken?
No. Your Honor, I'm talking about the PPRP conditions.
Okay.
I'm talking about the details because laws are broad. Even regulations are broad. The conditions I've seen, and this can be verified, and probably you have too, I've seen cases with 10, 15 pages of very, very, very specific conditions that go beyond anything that's been presented to you here. And you, if there is a dispute, we don't go to the agencies, the PPRP or we or staff would go to you. And that would have to be adjudicated, and you would be presented with a ruling on, obviously, if BGE contests it, then it's arguably an ambiguous conclusion, and you would have to decide that, not just decide the enforcement mechanism.
Okay. All right, well, thank you.
Commissioner O'Donnell.
Thank you, Mr. Chairman. Focusing on the conditions, and actually, it's the area that calls out a lack of conditions, the last 2 pages, but I'm concerned a little bit about the consultation with MDE for wetlands, streams, and their associated buffers. So I take it that did not occur in a formal sense because we didn't go through the interagency review of a CPCN? Is that right?
Well, Commissioner, I'll let Bob Studinsky cover that a little bit, but we did have some consultation with other MEA and MDE did have some consultation. It was marginalized from what it would normally be, but they the full review process did not take place. And I'll let Mr. Studinsky.
Good morning, Commissioners. Bob Studinsky, PPRP, and I was manager for the project, and I also did attend the site visit. But contrary to Mr. Hurston's statements, we did not walk the entire site. We stopped at 3 different locations. I personally did not feel safe stopping at 2 of those sites. I mean, I know I live on the Eastern Shore, but I mean, these were steep up and downs, and they even said we probably can't stop here because it is pretty dangerous to stop on the downside of one of these hills. In particular, I did coordinate with MDE, but via email, back and forth. Because of the RTE, the Rare Threatened Endangered Species, this is considered a Tier 2 watershed, so I wanted their language, so we went back and forth via email to get the language down for Tier 2. But even then, it was very difficult, like the bottom of the 9th inning, to get the exact language that you see here. And even then, like I said, it would be nice to have more time, because like I said, PPRP had to do a lot of this legwork behind the scenes and screen the project, et cetera.
So in a normal CPCM process, there would be a formal review, it would be formally documented, there would be formal sign-offs, interagency sign-offs, correct? On these matters.
Yes.
So these were kind of informal communications via email and...
Yes. And usually MDE would even be invited on the site visit, or I would attend when they could be there. So MDE would walk the site.
So similarly, even within your agency, your broader agency, the fisheries service doesn't have formal input on the impact of the fisheries in the state of Maryland.
I did not have time to coordinate with fisheries for the time of year restriction, just in case there is some in-stream work that needed to get done.
And,
for example, I don't know if there's brook trout in there, so.
Much to my chagrin, I have some painful experience with the Endangered Species Act at the federal level, and a little beetle about this big called the Puritan tiger beetle. And it's been the bane of my existence. But we do carry out the Threatened and Endangered Species Act for the federal government at the state level. We are the implementers of that. Do we risk, by going to a less formal process, giving concern to our federal brethren that we're not rigorously implementing the Endangered Species Act for them?
Yes, sir, in my opinion, that would be true. For example, we do have a species expert for this rare threatened endangered species who could not make it on site during the time frame.
Okay. And one of the lessons we learned out of the offshore wind orders that we put out was, once people get to see a picture of, a visual rendering of an installation, they may change their mind. For example, the city of Ocean City has gone off the deep end because they saw some visual renderings of these windmills that are going to be off the shore. And once they saw them, they changed their position 180 degrees and are now opponents of the project because they got a look at. You know, the first time they were told, well, it's going to be about the size of your thumbnail on the horizon. But when they saw pictures, they flipped out. And this says in here that it's not clear that anybody has seen any pictures or physical renderings. Is that true?
PPRP is not. That's a question for the applicant.
Because these things are going higher. That's really at the center, at the nub of the waiver request.
Yes, sir, and in different locations also.
Okay. All right. Yeah, I have some other questions, but those are the only ones I had with regard to the
Can I
conditions.
just follow up on one thing? In our first comments letter, we noted that these poles are very high, and that they could, for example, with the addition of 2 poles, be knocked down a few feet. I forget whether it was 2 or 3 poles, but that they could be knocked down. When I mean knocked down, I mean you would increase the number of poles somewhat, but because of that, the height would decrease as well, thereby causing less of your picture requirement, that they would be less disturbing of the aesthetic and people walking by, etc. I'm not an expert in it. I'm just mentioning in our first comments letter that we did note that, and that would be something that would be negotiated.
Do we know if this project, when it was originally installed, probably not, it's probably old enough, it went through any kind of process that similar to what exists now? We don't, probably not. Okay. All right.
Thank you. Do other commissioners have questions on the topic of any of the conditions in either the first or the second buckets? Seeing none. All right. Why don't we? And if PPRP has no other points to make on any of the enumerated or bulleted commission
I'm sorry.
bullets. Commissioner Linton, yes, please.
I think well, mine is not on specifically on the conditions, but just generally on the conditions. For PPRP, you noted that there were several areas here that you were unable to propose the conditions on. Do you have, if the commission were to move forward with this proposal as it is now, would you be able to present some conditions? Are there some potential ones you could present that are, I'll call them catch-all, to give us some information or something to work with here?
There are several, for example, I would walk the entire site. There's homes pretty close to one of these areas, and it seemed like they were using the right-of-way for their personal use, and I don't know if they owned it. It's one of those things, that's the section we couldn't walk in. So, we'd also examine the tower locations. Generally, we recommend moving towers. This is a relatively short line, so we don't know, but then again, we do have that rare threatened endangered species in the tower locations. We would try and shift, because right now the one tower, I believe, is within the 300-foot buffer we mentioned. We're not sure if we can actually move that tower. Oh yeah, the vegetative management plan also. For example, the spotted lanternfly is an invasive species just moving down from the Philadelphia area. So we definitely want removal of the tree of heaven, which is the preferred food source for them, which is also an invasive species. Most of the site that we walked was in ag. I'm not sure about the other site. But we did walk right around the stream area, and there is a pretty substantial woody, shrubby buffer in that area. And I could go on and on. So.
Okay. Well, no, that's good to know. So if it turns out that the commission moves forward, is there, for example, would there be a period of time where you would need to put together some of those catch-all type of conditions for the areas that you don't currently have conditions proposed?
So I think, if we could review a vegetation management plan, if have more time to consult with, within DNR and MDE and have more time possibly to bring them out to the site, then, more time is really what was required to try and to get these conditions done. That's why we were unable to get the required information and get there.
And Commissioner Linton, we wouldn't be opposed to working with BG&E and coming up with a solution if that is the way the commission would like us to go.
Is BGE comfortable with working with state agencies on some of these areas where there's not conditions currently proposed?
I think we would be more than happy to work with any party that has concerns. Condition 13 provides PPRP and staff full access to the project site at any time with, reasonable notice to see if we're adhering to the conditions that have been agreed to. If, for instance, they come out and they see something of concern, bring it to our attention. We have every intention of listening to them and adjusting any practices necessary to address that concern. I don't think that needs to delay the decision on whether to grant the waiver or not, though. I would hope that PPRP staff and OPC agree that we have been reasonable in this process and that we've been open and willing to listen. I'll represent to the commission here as I sit today that we will continue to do that. But this filing has been on pending for 5 months now. We've answered significant data responses. In our view, we would like to move forward with this project. But like I stated, we have no objection to them visiting the site, and if any concerns come up, we'll address them. And, to Mr. Alexander's earlier point, if somebody has a problem with one of our practices or procedures, or they claim that we're not adhering to these conditions, we will talk to them. We will come back before you. We can discuss that. And, if the commission feels we're not meeting one of those conditions.
Mr. Herson, I think the question was regarding where there are no conditions. You keep saying the conditions we've agreed to, but I think what Commissioner Linton was questioning, vegetation management and otherwise, were the list of things where there are no conditions for you to adhere to.
Well, if that's the case, I mean, if something is brought up to our attention, for instance, if PPRP is out visiting the site and they see something they didn't see before, and it's of concern to them, and they bring that to our attention, it is not our intention to be, well, too bad that wasn't in the.
But wouldn't it be in your right to say, we didn't agree to that?
It would be in our right, Commissioner, but I can represent to you today that that is not our intention. We're not trying to use the waiver process to avoid scrutiny, to avoid conditions. We're trying to use the waiver process to shorten the timeline to get the project done.
Right, I understand that, but these are legally binding proceedings that we're dealing with here, not handshakes. and
Oh, I agree.
intentions.
I agree, and that's why I'm stating to you today that if there are issues with respect to the conditions or areas that are not covered, you have not somehow waived your right to regulate us, to oversee this project, to call us back in here, to show cause. We will do that.
So,
So-
Mr. Herson, look, oh, I'm sorry.
No,
Go ahead.
Well, I just have one other follow-up then to it. See, we have 16 proposed conditions here that were agreed to as a result of your discussions. Were there other conditions proposed that were by PPRP or the other parties that were not agreed to?
All the conditions we were able to formulate a proposal on, BGE has agreed to. If there weren't any assessment, again, they have been. We've worked well together, and they've been very responsive. But in doing this from the last hearing to now, we have to make a decision. All right, we're not going to be able to get all this done because everything is a normal CPCM process, and we just don't have that. So we just had to manage which ones can we get done within this time frame, and which ones would we not be able to get done in the time frame, and we had to make that decision, pretty much a little more in advance of when we were meeting with them to make sure we had it ready. So it really was just timing issues.
So, Mr. Herson, I'm going to try to get at Commissioner Linton and Commissioner O'Donnell's question a different way.
Okay.
If the commission, would BGE have concerns if the commission were to condition a waiver on the development of conditions with PPRP on vegetation management, in-stream work, wildlife, rare, threatened, so on and so forth? I mean, would so that they, and I don't know how long that would take, and I'll ask in just a moment. But in terms of that way, the concerns of PPRP have been met, and hypothetically BGE gets its waiver at the same time.
But we couldn't begin construction until those.
Well, I don't know. I'm just trying to, I'm just trying to understand where we stand, because I think that what you're saying is, hey, they could come anytime they want and look at things, but at the same time, I think what you're hearing is some concern, say, with respect to vegetation management. I know vegetation management, you have a plan, and it's managed in a particular way, but maybe there is some, I don't know what, I didn't catch what animal was invading Maryland, but, or what, I don't even know if it was an animal or a lizard or whatever, with a walking fish maybe. But, if there was an invasive species. So I'm just trying to understand, where we stand, and maybe PPRP can tell me, how much more time do you think you would need to get where you were comfortable?
It really depends. I mean, there's some items on here where we would not be addressing, I'm not sure how helpful obtaining visual renderings now if we're not going to be holding a public hearing with them. That is an example of something we just wanted to point out that is not being done that we would like to have done. But BG's been responsive, and if they're responsive with vegetation management plan, and we have some more time to consult with our experts, then I don't see it taking 2 months.
2 months, okay.
How long would a CPCM process take?
That came up with, a lot, and a lot of questions, and I think the example we gave at the hearing in May was the Ringgold to Catoctin. That was a rebuild of an existing right-of-way, a 20-mile right-of-way, and that was 13 months for the entire CPCN from start to finish. And so, or 11 months, excuse me. And so no, that wasn't excessive, but I think, we've had 2 months to try and formulate this. I think 2 more months would have a reasonable conditions on the ones that we don't have that we would be able to do. Again, some we're not going to be able to do. But.
So Ringgold to Catoctin was 13 months, but that was from dead cold iron to final sign off, right? You're not a dead cold iron here. A lot of this work is done.
Yes,
right?
sir. No, yes, sir. That's why I'm saying another 2 months. I think we can have some reasonable progress.
But I'm asking you 2 months to have a completion of a CPCN, or 2 months to give me a more comprehensive list of conditions so that we can grant a waiver. What are we talking about?
A more comprehensive list of conditions.
That's what I thought. I'm asking, how long would it take you to complete a CPCN process?
Commissioner O'Donnell, that is subjective. It depends on what information we get when they file their application and what is exactly involved in the CPCN. Sometimes it takes a long time depending on the issues at hand, and if it's a smaller CPCN, it can take a lot less time, of course.
Okay, I understand that. That's generality, and that's true. I'm asking specifically about this case. I know it's hard to pin it down for you to say we could do it in 3 months, but a lot of the work is done here.
Could we have
I think based on the information we have now, I'd say between 7 months to 7 to 9 months. Probably closer to the 7 month time frame.
Okay,
since we have a lot of the information, it's a small line. But again, a lot of that builds in public comment notice, public hearings. We have to, review the public comments. So a lot of it's information that we would have to wait to receive, and they have the 30-day public notice. So that builds in time, not really on our side, but the process just builds in that time.
Thank you.
Mr. Alexander.
Just briefly, following up on Commissioner Herman's questions. It's something that's really obvious. I'm sure you all know it, but I still feel compelled to point it out. That if BGE starts constructing things while additional time and EVRP, they can't, I don't want to say they all can't, some of that can't be undone.
Well, PPRP, or BG&E might be able to build the line before PPRP completes this, right? Because the line was it 1 year construction, 12 months?
I'm sorry, I'm trying to remember.
No, we would start this summer and we would complete by the end of the year.
Okay. By the end of the year, okay. So if PPRP is using best efforts and takes 7 months, the conditions might be rendered after the project is in service. Mr. Alexander, continue. I cut you off. So.
No, I think that's it. That some of it could be I don't want to say all of it. Some of it could be, a pole could still be moved or something, but once you disturb the ground and do everything, it's often very difficult to undo it after it started. That's all. Again, I know you all understand that, but I just felt that it should be pointed out. That's all. Thank you.
I take a good deal of comfort in Condition 1, as was pointed out by Commissioner Richard, because it does require that the utility abide by all federal, state, local regulations. If they are in violation of a particular regulation or statute, the appropriate agency could take the utility to court. They would also be in violation of the PSC's order, so any of the parties could come up, notify the PSC and seek recourse here for any violation. I would be concerned, since we've already provided the parties with 2 months, an additional 2 months to craft a condition that I'm not sure how much level of comfort I would have with, because I don't know exactly how that condition would be drafted. It would be another catch-all provision, but I'm just having some trouble wrapping my head around that. Right? Do commissioners have, if we're done with discussion regarding conditions, are there other questions that the commissioners would like to entertain of the parties?
I'm ready to make a decision.
Okay, thank you. Commissioner Linton.
Thank you. I wanted to follow up on a point that Mr. Alexander raised regarding the concept of creating a new standard and how this case would fit under the good cause exception. I'm wrestling with the fact that the good cause isn't, that we're looking at here is a series of steps that we're taking prior to the filing to address a number of the concerns that would be addressed in a CPCN proceeding in order to allow the whole process to move faster. I mean, I think I'm characterizing that correctly. And so, in a sense, if we've moved forward with a approval at this point, then we've kind of given the signal to other companies that if you do those same types of steps prior to filing, that you could fit under the good cause exception. So, I'm not concerned about creating standards since, COMAR and the statutes, et cetera, we have plenty of standards here for regulatory purposes, but this is a different kind of standard. It suggests that you could reach out to customers, speak to elected officials, look for turtles and all these other things, and then make a filing and say, look, we can fit under good cause because we've done all of these things already. As opposed to, when I look at for example, the order from Pennsylvania, which I think this is it, some of these standards are standards that exist on the day of a filing, and so that's the piece the wrinkle I'm struggling with. So I'm wondering if Mr. Herson, if you or anyone else from the company, if you could help me try to navigate through that concern. Is that
Well, I heard Mr. Alexander's points that he made on precedent, whether it be formal or informal, and I think our position is that regardless of whether you call it formal or informal, going forward, we would have no expectation bringing a future waiver request before the commission that it would either be granted or denied based on what experience we've gone through here. Case in point, we had two prior discretionary waivers I believe we've brought before this commission. One was about a year ago. That was the Trade Point Atlantic site. And then there was one maybe 3 years ago, Conestone up to the Maryland-PA line. In my opinion, both of those projects were much more involved than the project that's currently before you. Those two projects were approved without these extensive conditions, and my recollection is those two projects were not objected to by the other parties that are objecting to the waiver being granted in this particular proceeding. So in our view, each one of these that we bring before you is a separate case, has separate facts and circumstances. It may be that PPRP states, hey, we want to impose the same conditions that we did before on the Five Forks case here, and we would certainly listen to them, review those, and if we could agree to them, we would. If we had issues with them, we would tell them we couldn't agree to those and why. And they can bring that before the commission. But I just want to stress that we have no expectation that you are locking yourself in to future decisions regarding waiver requests.
And I guess that's helpful, thank you, but I think my concern is on, and let me try and describe it by giving a different kind of example. This line that we're talking about today is part of a larger line. Right? It goes further out. So let's say that we approve this request for a waiver, and the company now says, okay, great, we start the work for the first 1.8 miles. But then begins the process of outreach, speaking to elected officials, looking at the land and the mountains and looking for turtles and flies and whatever else are out there to seek a second waiver for the next part of the line under the same provision. Now, it's a separate section. You're making a separate filing. You're pursuing it the exact same way, but the decision-making point as to when the waiver is requested happens before the filing. So it's not an existing standard. It's not a moment in time request for a waiver to say that the waiver is necessary for good cause because of a circumstance that exists at that moment. But the decision to request the good cause exemption and to create the exemption provision is being created by the company's actions prior to the filing. So I guess that's kind of that's the wrinkle I'm looking at. I mean, typically good cause is request or something that happens right in that moment. You can look at it and say, this is a problem that doesn't quite fit, so we can request good cause. But if we look at any of the line, even this line, at the moment you knew that it had to be updated or improved and repaired, it should have gone through a normal CPCN. But then the outreach of reaching out to customers and everything else was done. And then the request for a good cause was made. So that's kind of that's the standard that I'm struggling with, is that we're encouraging other utilities, Potomac Edison, perhaps they're watching on YouTube right now and they say, oh great, we can start reaching out to our customer base and talk to elected officials, and we can come in under the same good cause standard at some point in the future. They'll look at it separately. It's not the same thing, but we've taken the same steps.
Yeah, I think I understand the concern. Based on our experience with this particular segment of line, there may be best practices that we would employ going forward. So you're correct that, if we had elected in the future to bring a waiver, or let's say we hadn't even elected, let's just say we were looking at the project, saying, how do we want to approach this? Do we want to file a waiver request? We want to do a full CPCN? There are a number of factors that go into that. Some of them have to do with the length of the line. Some of them have to do with the actual construction work. Are we going through densely populated areas, or are we going through more rural areas like we have here? I think this experience could inform that decision-making process that the company makes about future projects like that. But I would be reluctant to say that we would go into a case like that in a filing with the expectation that we had to attach all these conditions to the filing. We might elect to. There might be additional conditions that we would put on there. We might do some outreach with PPRP before we even make the filing with the commission. I think, again, each case is going to have to stand or fall on its own merits. And even though we think, okay, that worked in this particular instance, so maybe we should do that process again, I couldn't sit here today and tell you in good faith that it would be exactly the same. I just don't know.
Okay. And I appreciate that. Thank you very much. And I also want to acknowledge the work that all of the parties did up until this point. I mean, certainly it's a little different. So I understand a little different means a little more time and work and commitment. So I appreciate that. Thank you, Mr. Chairman.
Thank you,
Can,
Commissioner.
can I make one point on what Commissioner Linton said? One of the concerns that we have is COMAR provides specific information that is needed in the CPCN process, and so we get that information at the beginning, and then we can start our review. With a waiver, we are not necessarily given that information. BG&E has reached out, and they provide information at some point, but it is not, we don't know what will be in there, we don't know what is not in there, and that presents a concern, too, as we continue with these types of waivers. I just want to point that out.
Mr. Chairman?
Yes, Mr. Alexander.
Two very brief remarks. One, I just would note that BGE is not committing to go through the CPN process for further aspects of this line or any other line. That what I heard is that they will evaluate it on a case-by-case basis, rather than saying, yes, we'll make sure that we go through the CPCN process. The other thing I'm just going to I hope you'll forgive me for just being redundant. It's the first thing I said. There is no need to build this line now. Nothing has happened in the last 5 years. All of the interruptions that occurred, the 7 or 6 things that were cited to this commission, like balloons, etc., none of that happened in the last 5 years. So what's the rush? I mean, I understand what Mr. Herson's saying, that, well, PPLP is taking care of its line, so let's ours take care of mine. But the question is, why should they have waited 5 years for PPLP when we had from 5 to 10 years things? So in the last 5 years, and currently, there is no need to do it now, immediately. There's a need, but it's not affecting anything. Literally nothing. So that's all. That's my second comment. Thank you, Your Honor.
Thank you. Commissioner Richard.
Yeah, I also want to thank the parties for coming together. This was the what I was hoped would come out of it. At least we'd have a list of conditions and the active involvement of our state agencies in the process. Because while we're looking at whether we're calling it a third process or whatever it is, the fact is the legislature did give us another path, and that is the good cause path. I don't believe it's a path to shortchange the process at all, but it is a different path. And I would just ask, do you think the legislature would give us something if they never intended us to act on it?
If you're asking me, Your Honor,
Or I guess
you do have.
PRC or
Yeah, well, I'll just say that, of course, they put it in and they meant it.
Okay.
We're just disagreeing with what good cause is. If there was some buildup, for example, just as a hypothetical example, let's say in the last 2 years there were 7 or 10 or 11 continued faults in the line. That BGE could come. They don't have to come in the first one. They wouldn't know that it's a big deal. But as the year proceeded and there were 3, 5, 7, I would say that they had an argument. Again, just like Mr. Herson, I can't say what our position would be, but I think that would be a good cause. It would be needed and needed relatively now. Again, doesn't have to be an emergency, but there should be some evidence that there has been a buildup and there will likely be a continued buildup, and let's do it quickly. And absolutely, the commission, the legislature put in the good cause. It is not surplusage. That would be to make it surplusage, contrary to every statutory interpretation case issued by our Court of Appeals. It does mean something. We're only arguing about how big, how wide the good cause should be to circumvent.
Well, again, the legislature has left this good cause to the judgment of the commission, and in that the utility has come forward and has made a case. And so we've had this procedure. We have the involvement of the parties. So again, it seems like we are following a process that's been given to us by the legislature. And then on the other hand, I mean, we have to, I think, be consistent, because in the past we've been somewhat, I think, hard on the utilities, or actually maybe appropriately tough on the utilities for maintaining their system, the distribution side of the system, and not being proactive enough in keeping it up and running, during the storms that led to RM43. So I guess there's a balance I'm suggesting, that we want to allow the utilities to operate their businesses, to maintain their facilities, and so in that, I think that we do have the opportunity to exercise judgment as to what process, if you will, we might follow. In this case, good cause may be a good route to follow.
In OPC's opinion, you do. Good cause is the exercise of judgment. You absolutely, the commission, in OPC's view, absolutely has, since it's not qualified. We agree with you, Commissioner, that you have the judgment. But in terms of what you were saying, for example, about maintaining the line, all the faults in this line were from 5 to 10 years ago. So why wasn't BGE maintaining its line then? That would be to our OPC suggests. But I just wanted to emphasize that the commission absolutely has discretion under the good cause. It's not defined as far as I know. And I gave one example that I could find of it's not an identical, an analogous one that I put in page.
Was it Savage Mountain?
Yeah.
Yeah, and I did read the filing. So anyway, part of the good cause is allowing the system operators to operate and maintain their system, and also maybe there are opportunities to look at ways we can lessen regulatory burdens and costs and those types of results from a process.
I've said
the one thing I did want to go to, we were talking about a little bit, as far as the bigger picture, another area I'm concerned of is just the whole concept of supplemental projects. So while I don't think that plays into the discussion directly today, given that this is a supplemental project and possibly part of a larger supplemental project, Mr. Chairman, I would just suggest that that's something we ought to consider, maybe down the road for some kind of a proceeding here, maybe a public conference, to bring our utilities, and particularly the transmission operators and find out what's going on with our, the bigger picture, what planning is taking place, and allowing us to kind of go at this question on that route. But I don't believe that plays into what we're doing.
No, I do believe that the issue of supplemental projects and the fact that the exception is swallowing the rule is a concern to PJM stakeholders and PSCs within the PJM footprint. So further examination of that is appropriate. Do you have additional questions? No. I believe the Commission at this point is ready to render judgment on BG&E's request. As we just mentioned, the Public Utilities article under 7-207B3-2 provides for a discretionary waiver if good cause is shown. Obviously, our argument is what is the good cause standard, and I believe that is up to the judgment of the Commissioners as informed by prior cases, our statutes, and our regulations. I do believe that the standard, in my opinion, was met to grant the waiver. We heard a long list from Mr. Herson this morning regarding the benefits that would come to granting the waiver. This is a relatively small project, 1.8 miles. No new property rights will be obtained. This will be replacing a line that has had significant problems in the past. I agree with Mr. Alexander that there haven't been any major splices or outages or avian interference in the past 5 years, but over the past 10 years there have been, and this line is not getting any younger. So we do have that I would dispute OPC's position that there is no physical connection. I think there is a physical connection, and in more ways than one, including the connection with the PPL line that will be upgraded in the near term. I am particularly concerned about environmental impacts, and I appreciate and do not want to diminish the professionalism, the work, and the expertise of PPRP in particular in their outreach. Here we have assurances in consultation with MDE that there will be no wetland impacts. There is one river crossing, a creek crossing across the Broad Creek. Steps will be taken to minimize any disruption there. No trees will be felled along the way, and I believe that granting this waiver will save not only time and allow this needed reliability repairs to take place, but it will ultimately save BG&E customers a substantial amount of money if the utility is allowed to enter service or begin construction later next month and enter service before the end of the year. That being said, I made reference to a number of the conditions or items, not conditions, items where PPRP was unable due to either a lack of resources or time to formulate any conditions. I do agree with the final bulleted item that there should be some public repository. So depending on how the other commissioners vote, my condition to my vote would be that we create a case number to allow a public repository for documents to be filed for informational purposes, and if there is any need for commission action, for instance, if there's a violation that was noted by a party, that could also be submitted in that case number. Currently, we do not have a case number associated with this matter. Commissioner Richard.
Mr. Chairman, I support pretty much all the points you've made. I believe also that the company has made a great or a good argument for good cause, and I think there are a lot of benefits to granting that. So I would support that. I would also condition it on accepting all of the conditions that PPRP has proposed, and I would also support the additional condition that we create a case number.
Thank you, Commissioner. And I neglected to say yes. I would grant the waiver conditioned upon the 16 conditions that were propounded by PPRP, in addition to that last condition that I mentioned. Commissioner O'Donnell.
Thank you, Mr. Chairman, and with all due respect to the Chairman and Commissioner Richards, I disagree. To me, being a creature of the legislature and having served there for 22 years, I have a pretty good feel, as do all the commissioners, of what statutory enactments are and what they mean and the powers they grant, and Commissioner Richards is absolutely right. The legislature did intend us to exercise our judgment in this regard. So to that extent, I agree. I just disagree on the judgment specifics. So, in my opinion, the certification of public necessity and convenience, or convenience and necessity, has a key word in it, and that's the public's convenience. That's the public's necessity. That's what we're deciding. Not the convenience of the utility necessarily, not the convenience of the agencies necessarily, not our own convenience necessarily, but it's the necessity and convenience of the public. That process is the repository that protects the public's rights in this instance, some of which I may agree with and some of which I may not agree with in a different life. Some of these regulations that will be considered in a CPCN process have been troubling to me at best. But they're there for a reason, and they're there for us to consider and follow. So when I look at this, I look at the things that are not considered because we're going to an abbreviated process outside of the CPCN process. That abbreviated process minimizes formally looking at protocols for wetlands protection. Formally. I know there's some informal looking at. That's probably MDE calling me right now. There's a lack of that formal kind of record being built to protect the public's interest. Time of year restrictions. The Fisheries Service and DNR has not been consulted formally to document the protection of the public's interest in our state's waterways and fisheries. Similar with wildlife and dwelling species, habitat in the right-of-way has not been formally documented as it would be. That's a public interest. Rare, threatened, and endangered species. Not only is there a federal act, but Maryland has its own act that hasn't been formally considered because there's been no formal process. Watershed impacts. Even through our own experience, public hearing and visual renderings, there has been none of that in this instance. And we can open a docket number up and throw dockets or throw papers into it, but the public's convenience and necessity hasn't been heard here. They haven't seen visual renderings. They haven't been given an opportunity, to my knowledge, other than going to ahead of time before this filing was even made and talking to some of the folks in the local area. That can change. Once you see a picture of what's coming, you can describe it and say, hey, we're going from this many down to this many. We're going to reduce the number of towers, and you can kind of mold the picture. And I think that's what the 3 letters that were sent did. But once you see a picture, you can change your mind, as they did in Ocean City very quickly. So the public's interest wasn't protected in that regard, in my opinion. Traffic movement, road permits, county coordination, no formal documentation with counties, and county governments change. But if you have a formal documentation in a CPCN process, at least you can point to that. It wasn't a letter that 1/20th of a council or 1/7 of a council, whatever it is, wrote. It's a formal communication with county governments and their planning processes. I think that's important to preserve. An official docket, as I said after the fact, is just troublesome to me. When I make the decision, we'll document it later. So with all due respect, I don't see that helps me at all. There's no good cause here beyond that. So I'm balancing protecting the public's interest with the good cause that the company proffers to us. And I don't see the need to rush past the public's interest to give the convenience of a waiver. I don't see it. I think we need to preserve these protocols. I think they should be done. There was never, because of the age of this system, this line, there was never any of these considerations taken into account way back whenever this old line was put into service. And I think we need to do that now. Even though some of those I may not agree with, some of those particular items I may not agree with. I'm sympathetic to the company coming before us. I'm certainly considerate of all the work that's been done. But I think in an expedited fashion, less than a half a year probably, we could get a CPCN out the door and still protect the public's interests. So I'll be voting against the waiver.
Thank you. Commissioner Linton.
Thank you, Mr. Chairman. I would vote to deny the request for the waiver. I do like the project. I like the concept of it. I recognize the need to move forward with the repair and replacement of the line. And I would certainly recognize the hard work that all the parties have put into getting to this point. I just don't think that the statute was drafted and incorporated the concept of a good cause as a reason for allowing the commission to create a streamlined citing process as a way of moving through the statute. I think that the statute already has a waiver provision built into it, and there are standards and conditions for meeting that waiver requirement. I'd be supportive of creating a process that was a little more efficient or streamlined along the lines of what Pennsylvania has. But I don't think that's something that we should do in a administrative proceeding in the manner in which we've gotten to this point. I think it would take a little more thought behind it. It'd take a little more consultation with the state agencies that have to do a lot more of the lion's share of the work. I haven't been out to the line, so I know they have to go out and do that work. So I'd like to give them that opportunity to do the work that they're tasked to do, that we rely on them to do. And I hear them today saying that they have not had that opportunity, and that's a heavy, that weighs heavily for me at least. So I think that the statute as a whole kind of gives us direction here as to what we need to do. I don't think that good cause exists at this point. I don't think you can create good cause. I think it should exist as you find it. And you're able to, because if there's a need for a waiver, then the statute already says what those standards should be. But good cause is something that you would find, and it would be unusual. It isn't something that you would establish by following the general terms of the statute and leaving out the ones that take more time. So for those reasons, I would deny the request.
Thank you. Commissioner Herman.
Once again. So I won't repeat what Commissioner Linton said. I agree with him completely. I would vote to deny the waiver. In this particular instance, I have voted for waivers in the past when I felt that there was good cause, and I agree that good cause generally is going to exist, not be created. I think that's an excellent point. And with respect to the fact that PPRP, who is our agency who is charged with making sure that the environmental and all the impacts are created, and they are continuing to object despite the ability to have created some time to create conditions. So I would vote against the waiver. But I would say that again, I also agree with Commissioner Linton that the project, I think, is a good one, and I would hope that PPRP, if BGE were to file a CPCN, PPRP would not recreate the wheel. It would use all the materials it's already done, and hopefully all the parties would be able to expedite this as quickly as possible and follow the CPCN process so that it can move forward as quickly as possible, because I do believe it is in fact a good project. Thank you.
Based on the vote of this commission, BG&E's request for a discretionary waiver is denied. Seeing no additional matters on this administrative meeting, this meeting is adjourned.